So.
Yep. Good morning, everyone. We'll just give it another couple moments here to let everyone in from the waiting room. We're still rolling in, but I'll get started. I see a question about when the YouTube session or when the sessions are up on YouTube. Ideally within a day, but there's no guarantees. Sometimes they take a little bit longer, but usually they're up within about a day. If there's something specific and you're not seeing it up there, let us know and we'll make sure to get it up there. I think people are still slowly rolling in, but I'll get started. I'm Lisa McMahon. I'm one of the collections attorneys at CLG, and I'm here today with Ken Hare to answer some of your questions. Today is February 21st. I'm not going to go through the typical Zoom housekeeping. I'm hoping at this point you know how to work that, but if you could stay muted, it does help us a lot with background noise, and so we can focus on answering all the questions. There are a couple of things. There is, if you'd like to opt in for the Legislative Action Committee to receive the Monday morning minute, there is an email address. If Chelsea could put that in, that would be fantastic. The legislative session started January 8th. And there's also a link, if Chelsea could put that into the proposed bill regarding Wokiowa for All, I guess we'll call it, that is currently pending. And just a final reminder that WSCAI is having a sort of a combined law day made for managers event. We're doing it all in one weekend this year, and it's April 19th through 21st. I think that's a Friday through Sunday. I'll be presenting along with another associate, and I think Valerie is also hosting a panel. So there should be lots of information there, and we look forward to seeing you there. With all of that, I think we can get started. And Ken, I think you've got the first question.
I do. Thank you. So when an association has a water damage claim and the insurance company determines the damage is, for example, $50,000, but only pays the damaged party $5,000, is the difference the responsibility of the condominium association. The expression used was the association is responsible for anything not covered by insurance. So this is a little bit confusing because I don't know why, if there's $50,000 of coverage, there would only be a $5,000 payment, but maybe it's because there was uncovered damage. The answer depends enormously on the specific facts and on the specific requirements of the individual governing document on how it allocates this risk. And so you need to look at the governing documents, and you need to look at things like, what are the boundaries of the unit? What part of the building was damaged? Are there limitations on liability for water leaking into the building? What are the insurance requirements? Is there a provision shifting the uninsured amounts to the individual owners? You need to look at the damage and destruction provisions, whether or not there's any misconduct involved. And the answer has a lot of variables, so we don't really know. But sort of as a general rule, if the association is responsible for insuring and repairing damage, which is the default for at least the first 40 years of most condominiums that were created, and there is not enough money from insurance to pay for the restoration of the covered property, which usually means the common elements and the interior of the units, the default is that it is a common expense for the community to restore it all. And you need to have an amendment to your declaration if you want a different result, if your documents don't already provide the different result you want. Anything to add on that, Lisa?
Nope, I don't think so. Next question. As new board members, we found out that delinquency letters have not been sent out by our managing agent to homeowners. When asked why, we were told that homeowners just don't open these types of letters and they go straight to the recycling bin. is she being negligent, not doing her job? We found we have a lot of delinquent accounts. The delinquency policy was not followed by the previous board. As a new board, can we just have our attorneys send out a demand to pay letter, or does the delinquency policy have to be followed first with whatever letters are required by that policy? And it's at the end of that is so that we don't get sued. The first thing I would say is for sure talk to your association counsel here. You've got a lot of potential issues. Just starting with statute of limitations questions, I have no idea how long this has been going on. And also whether or not you need to send out letters first. Generally speaking, we would say that you would want to follow your policy and at least send out one letter, especially if homeowners have absolutely no idea that they are delinquent. But you probably also want to talk to your association counsel about whether or not it makes sense to update your collection policy. There've been a lot of changes in the past few years, and this might be a perfect time to sort of start fresh, and then have the ability to resend out the policy to all homeowners and let them know what to expect and what's coming. I'm not going to comment on whether or not the manager has been negligent. We're just here to give general advice or general information, not legal advice. So if you have specific questions, you may want to talk to your association counsel about that. Anything I missed there, Ken?
I guess the only thing I might mention is that if they've been sending electronic notices instead of mail, and the owners have opted into electronic notice, then they may have been complying with the policy with, maybe unintentionally, but it is possible for notices to be sent electronically for owners who have opted in. And so an email is legally just as effective as a written letter. I think, do normally suggest that you use both methods of notifying owners because you are more likely to get a response from the owners.
That's correct. Yeah.
Third question. We are an HOA community with 5 board vacancies to be filled at our annual meeting. If only 3 homeowners run for the board, are they automatically elected to the board? Is there a need for an election? So this is, I'll say, has some exceptions, but normally we would see the people who are willing to serve get elected because there are no other people voting or running against them. But I do believe that an owner has to get a majority of the votes cast to serve on the board. And so if you, as a community, were trying to exclude a board member or exclude an owner from serving on the board, then you need to have an election which would say yes or no to each of the 3 nominees serving on the board. We have at least one client where for 5 years in a row, one person who wanted to serve on the board got more no votes every year than they got yes votes. So they did not serve on the board. And he had tried to challenge that, I think, for all 5 years, but he didn't have a valid way to get past the court and on the board. So if you only have 3 nominees and no quorum, then the existing board members could certainly just appoint them and have no election. If you have 3 nominees, you can have a motion to just appoint by acclamation because you have no more people than there are positions to fill. And so that single motion, which you could probably pass with a voice vote or show of hands, would probably suffice instead of an election process with ballots. So it kind of depends on the circumstances and what you're trying to accomplish. If you want to have a record that every board member has actually been elected by the membership at the quorum, then use a process which would give you that record to fall back on. Anything you want to add, Lisa?
Just that you had mentioned previously, Ken, that a ballot with a yes and a no on it is useful for that situation when you have a board member, particularly that you don't want to be elected. Then you've got a record of the no votes as well.
Yes,
instead of just a 4 column, I guess.
Well, that's correct. You need to actually have a yes/no ballot so that you can count the number of yes votes and compare it to the number of no votes.
Right. Okay, next question. I was wondering if the topic of reserve study exemptions could be discussed. I have a small HOA of 24 homes with an annual budget of about $19,000 that I believe is exempt based on RCW 6438090. The reserve study would exceed 5% of the budget. However, RCW 649545 seems to contradict with a 10% of budget mention. Any clarification on this would be helpful, I believe. So the person who asked the question is correct to look at RCW 6490080, or sorry, at 6490545. If we start with 6490080, it specifically states that the budget provisions of 649525 and 649545 apply to all common interest communities that were created prior to Wakaiowa, which was July 1st, 2018. It says that any inconsistent provisions of the chapters like 6432, or as the questioner asked, 6438, do not apply to a common interest community created in this state before July 1st, 2018. So that statute answers the first part of that question. We don't look to 6438, 090, and the 5% budget question. We look to Wakaiowa, which does have, as the person writing mentioned, 10% of the budget. So no matter what type of community you're talking about, you're required to have a reserve study. Remember, this isn't coming from us, this is coming from the legislature. And you're required to have that reserve study unless under 6490-545, section 2, you only have a minimal reserve cost, or when the cost of the reserve study or the update to that study exceeds 10% of the association's annual budget. And then there's also a caveat that the statute says in subsection 3 that the governing documents could impose greater requirements. So the baseline is 10%. It is possible that your documents, and the statute allows, could provide for a higher percentage. But the short answer to all that is you probably have to do a reserve study unless you have a tiny budget and the cost of the reserve study is less than 10 or is 10% or more of that cost. Anything to add to that, Ken?
Well, two comments. One is that this is a good example of why there is a push to have a single statute which governs all communities, because you do get this very conflicting language in the statutes and people don't understand how to find them. And then the second one is that there's not a particularly significant penalty for a board's failure to get a reserve study. The statutes actually say that if the board fails to get a study, there's a remedy that the owners get to sign a petition and require that the reserve study be included in the following year's budget. So if the reserve issues really are minimal, then it is, perhaps okay for a client to make a reasonable determination to not spend the money and wait to see if the owners use the remedy they have available for that failure.
The key in that situation is to make sure that you disclose that information on your annual budget disclosures.
Yes, I
as required.
would rather clients make informed decisions to do something wrong rather than to just fail to do something or fail because they're ignorant about it.
Yeah.
But that's again something I might ask for advice from someone before I take that step. Next one is, in general, does a condo board have a duty to deal with excessive noise coming from one unit's aging HVAC machinery mounted on the building roof? It disturbs the sleep of another unit. Does it depend on the declaration or specific rules adopted by the association, or does the board have some inherent duty to deal with problems because the noise is coming from machinery installed on common property? So we end up with again, multiple factual things, which mean I cannot give you legal advice on this. And it's going to depend to some extent on the specific requirements of your documents. If we assume that the HVAC equipment is entirely the responsibility of the unit owner to maintain, then I think that the association has the ability, but not the obligation, to require that the owner maintain the equipment and restore it to a reasonably quiet condition. So part of what this would require is that the association make a determination that the piece of machinery needs to be maintained. And part of that may mean that they have to make a determination that the noise created by it is an unreasonable noise and is a violation of the condominium declaration. So we usually do suggest that the requirements or the privilege in RCW 6490-405, I think it's sections 7, 8, and 9, which talk about a board's ability or obligation to enforce their rules, regulations, CC&R, and that they do not have to enforce if it's not in the best interest of the association. And so with neighbor to neighbor disputes, we often think it's not in the best interest of the association to be involved, but it is going to be the association's obligation, typically the board's, to decide whether a violation of the governing documents has occurred or not. So it may be that the board has to listen to the noise and make a determination that the noise is a problem, because we have certainly situations where an overly sensitive owner is complaining about noise and they don't belong living in multifamily housing because they expect to hear nobody. We have other situations where there's legitimately noise that should be addressed by a neighbor. And it is the board that gets to make that subjective decision on whether or not a violation exists. Once they've made that subjective decision, they do not have an obligation to force the owner to repair the equipment. That could be left to the neighbor who's upset. It doesn't mean they couldn't take some effort, but they would not be able to sue the owner, I don't believe, because the statutes say that the authority to sue is only on behalf of 2 or more owners. So they could not sue one owner for the benefit of another owner, even if there was a clear violation of the governing documents. And if you're getting into a question like this, you should probably be consulting with an attorney to make sure that the actions that you take are consistent with your documents and the facts and circumstances involved. Anything else, Lisa?
Nope, not on that one. Let's see, next question. In a single family home HOPA community, are individual owners required to include 55 plus verbiage in the rental or for sale ads if the governing documents don't say anything about the content of advertising? And for those who might not be as aware, HOPA is the Housing for Older Persons Act. Generally speaking, the HOPA requirements are as to the community itself or the housing provider, not the person who owns the unit. You're going to want to talk to your association counsel if you have specific questions about this. But generally speaking, the owner doesn't have the legal requirement, but there needs to be the signage at the community needs to identify the community as HOPA. If they have a website, it needs to identify the community as a HOPA community. Anything that's sent out, the governing documents, resale certificates, et cetera, all need to specify that this community is a 55 plus community and subject to HOPA. But as far as we're aware, the individual owner themselves does not have a legal requirement to disclose that in their rental or for sale ads. Anything to add on that, Ken?
Well, you could certainly have a rule or tell owners that they should
Yeah.
do it. I just don't know that we would recommend any kind of enforcement action for failing to.
As long as the other stuff is there, it should be,
Yeah.
people should be aware of it.
Next question is it required or advisable to have "do not enter water" or similar signs next to a water feature in a common area? So again, this is one where I don't have nearly enough facts to give a reasonable answer, but this is a question about what in legal terms, we would call an attractive nuisance. And we would, we normally don't get involved in this except to the extent of advising our clients. So the question in my mind is really, is the risk obvious? Because if the risk is obvious, you do not have to have a sign. If the risk is not obvious, then a sign might provide you some protection if someone was hurt, because you have given them warning of the non-obvious risk. But it's really going to depend a lot on what you're calling a water feature. If you're talking about a little fountain in front of the condo building, or you're talking about a lake in the middle of a homeowner association, those are both water features, and they're going to have very different risks, and it'll be different what risk is obvious to a normal person. It might also depend on who your population is. That's, you know, if you're in a HOPA community, maybe it's a different standard than if you're in a community full of single family homes with children. So again, we might suggest if you're concerned about it, you talk to either your insurance company, who might be able to advise you on whether or not some precaution should be taken, or talk to your attorney to see if something should be put up. Anything to add, Lisa?
Nope. Okay. Next question. Can a homeowner make a claim on the association insurance for distress if the board is not following the delinquency policy, which is causing distress to that homeowner, knowing that they're going to have to cover the costs and shortfall along with the other homeowners, or in an increase of assessments for the following year? The first thing I would say is that the only group who has authority to file a claim against an association insurance policy is the group that governs the association, which is the board. So an owner cannot file a claim. However, the owner could, in theory, sue the association, and then the association's insurance may step in to defend that claim. It would more likely be that the owner could sue. I mean, it's possible that an owner could sue for intentional infliction of emotional distress. These are kind of, it's kind of interesting. I haven't seen this particular question come up before. There has to be a measurable damage to the person's injury, the tort injury to the person. You know, I think this is definitely something, if you've got a threat from a homeowner about this, talk to your attorney, your legal counsel about this. You know, there always should be equal application of association policies. So if there is a concern that maybe some people aren't being treated the same way, that some people's assessments aren't being collected the same way, you know, that's definitely something to look at. And that may or may not be known to the community, that there are reasons why one person may or may not be collected against. And if you are this particular owner and have concerns about the way your board is handling things, you know, certainly communicate with your board, or volunteer to run on the board, join a committee, et cetera. I think, yeah, I think I definitely would encourage this person to contact their association counsel, but you know, I don't really have a great answer on whether or not that is distress, that is a recoverable damage on a policy if an owner were to sue the association. Ken, do you have comments on that?
Well, I think it'd be unlikely that they could successfully assert a claim. And in part because there also are potentially a lot of legitimate reasons for not following a delinquency policy.
That's right.
You know, especially if you look at our history over the last 4 years with the pandemic, there was a significant reluctance on the part of associations to be aggressive in collections during the pandemic, especially the early part of it. If you were in a community that was located near Boeing, and Boeing had had a strike, and a lot of the members were unemployed because of the strike, and it might be reasonable for the board to choose to take a holiday, as it were, on collections. Because the fact that they're not following the policy doesn't translate to not recovering the money. You know, if you've got a 6-year statute of limitations on the delinquent association dues, failing to do anything about it for 1 or 2 years doesn't actually result in a financial harm to anybody. It doesn't translate directly into some other owner paying additional money. And so you have to look at more of the facts and circumstances, and kind of, as with everything, the details matter. And it may be that the board has made a knowing decision to delay collections. Maybe they should have rewritten their policy to reflect that, but they don't have to do that. If at their board meeting, they're instead choosing to, delay their collections activities for 2 additional months, or, whatever it is they're doing. So that's partly why I think it'd be ridiculous to try and assert a claim like this. But, I agree, the owner cannot make a claim on the policy trying to recover any money.
I guess we should also note that we don't know how they're not following the delinquency policy. Could be that they're waiving late charges or interest, which may again be a reasonable decision under some certain circumstances that this particular homeowner isn't privy to. There are lots of reasons that this could be coming up. And I think that's also, we kind of touched on, we were discussing before. I mean, the cost of living in a community is that you're all shouldering costs together, and costs go up and down, and that is a common occurrence every year. Insurance costs go up, and people's share changes.
And, I would say it is, I think, still true that most delinquent accounts are collected. It just gets done so in a more painful and expensive fashion than if people paid their dues on time.
That's right.
So,
I'm the painful and expensive person.
all right. So next question. I'm reaching out to inquire if rules and regulations changes by the board of directors are required to be voted on by the membership, or if the board can at any time by majority vote make board resolutions to change the rules and regulations. So the answer to this depends on, first, your governing documents, because they may have specific provisions. And then it depends on whether you're a Ukiah community or one of the other 3 statutory formed communities. So the general rule for a non-Ukiah community would be that the board of directors gets to make the rules as they are given authority in the governing documents. So the rules cannot conflict with what is in the governing documents. So, for example, if the governing documents say that owners can have dogs and cats, the board can't adopt a rule that says no dogs, because that would conflict with the rights and obligations provided in the governing document. On the other hand, they could adopt a rule probably that says dogs can't be bigger than 30 pounds, because it's still allowing dogs. And if there's a reason for having dogs limited to 30 pounds, then they can have a rule that reflects that. If you are a Ukiah community, there is an obligation in the statute that before the board can adopt a rule, it has to send the proposed rule out in advance for the membership to have an opportunity to comment. The statute doesn't say exactly how much time in advance, but we would normally suggest something like 30 days would be reasonable. And the opportunity to comment could either be that people can come to the board meeting and say something before the board votes, or you could request written comments, but there has to be some way for the owners to give feedback to the board before that vote is taken at the board level to adopt the rule. And then many governing documents actually have specific provisions that would grant the membership authority to either adopt rules or to reject rules which have been adopted by the board of directors. And so if you have those provisions in your documents, then you have to follow those because they supplement what the statute has to say. And then there's also ultimately the authority to remove board members if they're adopting rules that you think are not reasonable. At any time, a community can remove a board member or remove the full board if they feel like the decisions don't represent what the membership wants. Did you have anything to add, Lisa?
Nope, I don't think so. Let's see. Next question. When an association member requests a copy of the owner roster with contact information, are there any restrictions or best practices regarding providing owner information, including address, phone, email address? The documents and bylaws are silent regarding this issue. We've had lots of discussions on this topic because what it relates to are records requests. And the statutes changed this past summer. Regarding what can and what should and what must be provided and what cannot be provided to owners upon request. All the sections, all statutory sections are similar. Generally speaking, the association must retain records that include the names of current unit owners and their addresses. And if an owner, well, actually, not even if an owner requests, but the association must provide to owners the names and addresses of all owners within their association, but they must not provide other contact information, specifically email, phone numbers, etc., without that owner's consent. So the key is, do you have consent of the owner whose information you are providing to provide it to someone else, absent their address and the name on the deed? All records are able to be reviewed and examined by owners, aside from certain things. And we've talked about that at length before, but certain, information about particular units may be redacted or restricted. So if you want to share specific, like have a company-wide directory, for example, you're going to need to make sure that you have every owner whose information you're going to be providing's consent to do so for that directory, unless you're just going to provide their name and their unit or lot address. Valerie did point out when she made a comment on this that there is a statutory prohibition against distributing someone's information if they are a participant in an address confidentiality program. So make sure that the person, people's information is not disclosed if they are part of that program, and I'm certain they would have let you know that. But so to recap, address and name are okay no matter what. Phone, email address must have consent of the owners to provide that to other owners. Anything to add to that, Ken?
Well, the only thing I'd add is that when the statute was revised last year, the legislature created an ability to charge owners for getting information from records. With an exception, they did state specifically that you have to give an owner a copy of the list of owners and their mailing addresses for free every year. And so really the short answer is don't give out emails and phone numbers. And what we find is almost every record request, when an owner asks for the contact information for all of the other owners, they want the email distribution list, which the board or the management company is using. And the answer is no, you cannot give that out. All right, next question. If bylaws and policies are silent, who has the right and responsibility to set the agenda for board meetings, the president or the secretary? If the secretary sets the agenda, does the president have the power to remove items from the agenda? So this question really makes me wonder what's going on this board of directors. If you search on the internet or look at Robert's Rules of Order, it basically says that as a general rule, the agenda is set by the person presiding over the meeting, and that is normally the president of the association. But I would also offer that any agenda item that any board member wants to have on the agenda for board discussion should be on the agenda. And if it's not on the agenda, any board member can make a motion during the meeting to adjust the agenda. In fact, under Robert's rules, one of the first things you would do at the meeting is adopt the agenda which has been presented, or you have a motion to modify the agenda or dispense with the agenda, or you can at the meeting have a vote of the board to change the agenda. And so one person, even if they're the president, doesn't have the power to just remove things from the agenda. And if someone wants to add something to agenda and they don't have a second board member support it, it doesn't get added to the agenda. So there are rules in the Roberts Rules of Order to try and make sure that every issue can be covered, but only issues that have at least enough support from two of the board members to be discussed, so that one person can't just keep bringing up one issue and bitching about it over and over, meeting after meeting. So I kind of wonder what's going on, and, don't want to really know because it's legal advice then, but the general rule is the president's going to set the agenda. And if the agenda doesn't meet the needs of the full board has the power at any time, the beginning of the meeting or during the meeting, to change the agenda by adding items, deleting items, or changing the order in which they are addressed. Anything to add, Lisa?
I would just add that, I think practically speaking, often if there's a manager, the manager is the one who's technically probably setting the agenda and sending it out to the board. So that may also be help. And there are a lot of, if you need help drafting an agenda, you can just sort of Google association meeting agenda and you can find those online if you need them.
I'll add one other thing. There is something called a consent agenda, which some associations will use, and I used to use it when I was on the board of my credit union. A consent agenda is a way of quickly disposing of all of the action items which are not controversial. So if you've got an action item of approving a treasurer's report, or paying a bill to the landscaper, or, I don't know, approving an ACC modification, it can be on a list which is detailed in the agenda, and you can have a single motion to approve every one of the items on the consent agenda. And so the way that we would normally handle something like that is the consent agenda is published in advance, and the first question from the person presiding is, do we need to remove anything from the consent agenda for specific discussion? And if any one of the board members says remove an item, you simply remove it from the consent agenda. And then you have a motion to approve all the remaining consent agenda items. And they're done. You don't have to have, 6 or 8 motions and kill a bunch of time. And it still provides for discussion of every item which any board member cares to talk about. And so that's a way of trying to streamline things. So that's all I got. Thanks.
All right. Next question. In regard to board actions, it seems that a board can act with impunity, and the only consequence for board members is if a homeowner is willing to sue the board and then the homeowners end up footing the bill. Is that right? Lobbying to remove someone from the board in a community where no one wants to be on the board is more of a punishment for the homeowner than for the board member. I would start off by saying there's a lot going on here that we don't know about and probably can't cover, but generally speaking, if a board member, I don't know what the questioner is saying with the word impunity, but generally speaking, if a board member is acting in good faith for the benefit of their association, they do have significant protection. So to answer the first question, yeah, that is right, as long as they're acting in good faith for the benefit of the community. And owners can get community support to change decisions by changing the board. And as you indicate in the question, that can be complicated these days, trying to find and get people to volunteer. But that is a real option. And they certainly can sue if the actions are a violation of law or a violation of the governing documents of the association. And those procedures should be set out in your governing documents regarding recalls of board members by owners. But generally speaking, it sounds like there's a lot going on here, and you, as a homeowner member, may need to seek counsel from an attorney who specializes in that kind of representation. Anything to add, Ken?
Well, I'm, as we talked about this more, sort of stricken by what appears to be an owner who is objecting to the actions of the board, but not willing to serve on the board themselves. And that is, always sort of surprises me that you want to challenge or question the board decisions, but you don't want to step up and do the work yourself to understand the circumstances and facts which led to that particular board decision. So
It could be that this is also another board member, but that is a fair point.
yeah. So next question. Under what circumstances is it okay for a board to exclude one or more board members from a decision or board meeting? Okay. So this will always depend specifically on the facts. If there is a conflict of interest, so let's say you're approving a architectural control request from a board member, we think that that board member should be recused or excluded from that decision because there's a clear conflict of interest or self-interest in that. In terms of adversarial board members or people who are threatening or have some kind of a position which is contrary to the board. So a board member says they're going to sue the board if they make a certain decision, something like that. It is possible to exclude them from sections of a board meeting that discuss that issue. And we have in the 2018 copy of the condominium law book, which is available online, and people haven't seen them. We have, I guess my computer won't let my book show. We used to print and publish books and hand them out at CA Day every year before the pandemic. And so the books have questions similar to what we're answering today and answers with citations to case law and to statutes. And so chapters 24 and 25 from the 2018 book are specifically about how to exclude a adverse party who is on the board from the discussions and gives the legal rationale for how to hold a meeting without them. It's also possible to form a committee of the board, which would be done in a full board session, and assign duties related to the decision that has a conflict with another board member to that particular committee and give that committee the authority to make the decisions. And it all has to be documented properly in board meeting minutes. But it is a way to have the business conducted without the party whose interest is involved having information about the discussion or participating in the vote. So anything to add on that, Lisa?
No, I'll just say if people are interested in there are PDFs of the book and I think chapter by chapter on the website, but if you aren't able to find it, if you email info@condolaw.net, Chelsea should be able to help you out, help you find that information you're looking for. Next question. There have been many Q&As over what the boards are doing wrong. Is there any guidance on the following? Number one, disruptive homeowners. Number two, guidance on homeowner forum and meeting guidelines. And number three, this is a community. What are the responsibilities of homeowners in that community, or where can we find information about that? To discuss generally, we have discussed this quite a bit previously in other Q&As. There are information as Ken mentioned in some of our books. The 2017 book, chapter 36, talks about expelling disruptive owners from open meetings, if that's what we're talking about. If you're talking about disruptive owner at a meeting, check out the book there. You can also just Google it or check out the CAI message board, the discussion forum. There are lots of conversations about what to do with a disruptive owner, things like having a code of conduct, potentially having a parliamentarian or someone who kind of enforces the agenda, and if you're on Zoom, turning off microphones for people who continue to interrupt, or in extreme circumstances, even helping that person leave the room with security or police presence. And I think that kind of goes into the question number two, which is, guidance on forum and meeting guidelines. And sometimes all people want is to be heard. And what we have started doing in our bylaws, and what a lot of communities, if the message boards are anything to be believed, are doing, is putting something in your bylaws that allows for homeowners to talk either at the beginning or the end of the meeting. Set a limit, maybe a couple of minutes, 3 minutes, and don't engage with whatever they're talking about. Let them talk, say, great, thank you for your comment, and move on to the agenda of the meeting. Sometimes just letting someone speak is really all they wanted, someone to listen to them. You don't need to resolve their questions or comments or concerns right then. You can take a note, and if it's something that needs to be brought up at a later meeting for later discussion, it can be. And I guess that sort of flows into the final questions, whether responsibilities of homeowners. You know, it depends on what the question is. It's pretty broad. If we're talking about, is this a neighbor to neighbor question? Is it a violation of community policies? You know, we don't have the answer to tell you what to do with homeowner apathy. If people want or don't want to become engaged in their community, I'm not sure we can help with that. But again, you may find the answers in communities like the message boards, to promote community harmony. But I think, you know, the first step is letting people talk and letting people feel heard can often go a long way to stopping the disruption of certain homeowners. Ken, anything to add to that? Sort of an open-ended question there.
Well, to your thoughts about the owner forums, Ukiah does have now a statutory requirement that at the membership meetings of the association and the board meetings, there must be an opportunity for owners to comment. It's not an opportunity to participate in board discussions, but there must be an opportunity to comment. And so we would typically just put on as an agenda item that an owner forum, and we would usually do that first and give people 2 or 3 minutes apiece to talk, and the board just listens. They do not respond, and it usually goes fairly quickly, and it fulfills the obligation for the board to allow those opportunities to comment. Next question. We have an owner who disagrees with and argues with every decision the board makes. In the past, the board has, as a courtesy, emailed or posted to the association's website his letters to the ownership. He continues to demand that the board send his letters to the ownership, and it is costing the association money and management fees. Can the association bill these costs to the owner? Can the board end its practice of sending the owner's arguments out to the entire community? So, unless there's something different in the governing documents for this community, which I don't know about, I would say that the answer is there's no obligation of the association to distribute an owner's letters, whether it's electronically or in a paper form. And you need to, I'd say, be consistent amongst how you deal with all owners. So if you're distributing other people's communications, you'd have to distribute his. But if you don't want to distribute his and don't distribute other owners' letters, then you're not violating any law, and you're probably not violating any of the bylaws or articles of incorporation we typically see. So an owner has the legal right to the name and address, mailing address of every other owner. We already discussed that today. And that is the method that the legislature has guaranteed an owner as a way to communicate with all of their fellow community members. The board does not have to provide an easier method and does not have to provide one that is low cost to the individual owners. Anything you want to add, Lisa?
No, I just thinking this would be a perfect owner to have that owner forum 3 minutes for. I mean, there's no reason for the board to have give him more fuel for his fire after the meetings. Okay, next question. who will be held accountable for not filling the BOI form? It's beneficial owner information form, I'm assuming. We as a management company act as the registered agent for our clients, but we can't guarantee that the board members will provide us with the required information on time. The first thing I would say is any accountability a management company may have is probably governed by the management contract they have with their individual association. So if, generally speaking, if someone's acting in good faith, they probably don't have liability, but that's going to be governed by their contract. I'm assuming, again, I've meant to mention that this is probably talking about the Corporate Transparency Act, which is sort of the buzz right now. I would note that they have deferred the initial BOI until, I believe, next January 1st of 2025. But since this is a question coming from the management company, I would say, you may want to talk to your own legal counsel because we typically don't represent management companies directly. And so there are exceptions to liability portions within the statute, and it's certainly something that would be governed by your contract to the association, whether or not you have liability for certain acts. So I think that's where I'd end that. Anything to add, Ken?
Well, this came up with a couple of clients last week. We are, for the most part, advising people to hold off on compliance today, partly because there is an effort which is being spearheaded by National CAI to ask Congress to delay the implementation of this act by another year, partly to clarify whether or not homeowner associations are exempt under the act because they probably qualify as 501c4 tax entities, and there's an exception for those. They're also trying to get Congress to amend the statute so that it clarifies that homeowner associations are not required to comply. So if any of those things actually happen, then you don't have to take the effort to try and comply. The other thing is that if you don't have to comply till the end of the year, you might want to just wait till the next set of elections occurs so that you're not updating it already before you had to comply with the first time. So there's still a lot of questions. There's a lot of talk about it right now, and that's at the national level mostly. And so even though there is a way to interpret it as strictly requiring compliance and reporting today, there's no reason that we can see to report before July at least. Get your annual meetings out of the way, see if there's a change in the landscape. What I expect is there will be a panic in November and December of people trying to comply because Congress may not act before then. Anything else, Lisa?
Nope.
All right. In general, if a repair is needed inside a condo due to failure of a common element, can the condo association choose the vendor if they're paying with, if the association is paying, comma, without input from the owner to approve the vendor selected by the association for the repair? Does the owner have a say in who the vendor is? Okay, so there's a lot of assumptions in this, and that is that the association is required to do the repair. And I'm not commenting on that. I'm just going to take that as a given. Most of the governing documents give the board the full authority to select the vendor who does the repair if the association is responsible, even if it's inside the unit. That doesn't mean that having the cooperation of the owner isn't incredibly helpful. We would normally advise a client if an owner is objecting to a vendor to find an alternate vendor, but that does not mean that you have to use the owner's vendor of choice or pay a higher price. One of the things which frequently happens in these occasions is that a independent adjuster has made some estimate of what the cost of repair is. So insurance adjusters do this all the time. They're very detailed. They use a piece of software called Xactimate, and they establish a fair price for the work to be done. And so often there will only be a single contractor who is talked to. You won't get competitive bids because you have this independent evaluation of what the price should be. And it's okay to just start work right away to restore the property. So, there are certainly circumstances where if an owner objected to the vendor of choice from the board, we might want to look at the reasons why, or, look at the cost differences, or if the owner is willing to pay any additional cost that might be occurred above that objectively established value. We would want boards to work with their owners cooperatively to try and get the work done, even if the board has the full legal authority and easement rights provided for in the declaration to go into the unit and perform the work, because we would rather you be cooperative than confrontational. Anything to add, Lisa?
No, but the next question is also about insurance. I think it's basically our last. Regarding the deductible, if the master policy has a high deductible, say $25,000, that the homeowner or their HO6 policy is responsible for, is there a cap on the deductible that the HO6 will pay? Would the association or the homeowner pay the difference? The short answer to this question is, if the owner's policy limit is less than what the association's deductible is, then yes, the owner is responsible for that unpaid amount. However, the owner has to know what the association's deductible is. So as Ken pointed out, we were talking before, if the association has changed its policy or changed its coverage in the past year and did not tell the owners that the deductible changed from, say, 10,000 to 25,000, and the owner has a policy based on the belief that the deductible was 10,000 and they only maybe have $10,000, $12,000 policy, they may, it's a question, may not be required to foot the remainder of that deductible if they didn't know about it. So certainly talk to your counsel if you have questions about that. And make sure that if you are changing your policies or changing your deductibles, that you are providing notice to your owners so that they can, on their end, contact their insurance companies and make sure that they're covered. This question is the same if the owner doesn't even have insurance. If the owner is aware of the association's deductible and is required, whether or not they have insurance to pay that deductible, they pay it. It's their responsibility, whether they have insurance to cover that portion or not. Let's see. Yeah, so it doesn't matter whether the owner has insurance or not. Anything to add to that, Ken?
Well, I do want to make sure we understand that this is under the assumption that there is an obligation of the owner to pay any part of the deductible.
Correct.
Because the default under most older condominium declarations, and by older, I mean as recently as 3 and 5 years, the default is that the association pays for the uninsured amounts as a common expense. So this question is only applicable if the owner is responsible under the terms of your declaration to pay the uninsured amount and the deductible for their unit. And so that's the limit. So our last question is just about if we learned anything at the National CAI Law Convention, which occurred last week. And I didn't go because someone had to stay here. 4 of our attorneys went, including Lisa. But I think that because we're out of time and because they covered so much, we'll just offer, we can't summarize what went on with the law conference. The only thing I heard clamor about was the Corporate Transparency Act, and we've already covered that today.
Yeah, I don't think there was anything, some years there's something earth shattering that we're all going, oh, but I don't think there's anything this year that we felt that way about. It was a very interesting and informative session, however.
Well, and I think with that, we're done for the day, and we'll see everybody next week. Thank you.
Thank you.